Welcome to Bloomberg Law on Demand. I'm Pacchia. NFL owners were ordered by a federal judge to end the player lockout this week. The owners are appealing that order while seeking a stay of its enforcement. Will the dispute between NFL players and owners be determined in a court of law? Or can the two sides come to an agreement? Joining us now to discuss the players' side, their representative, James Quinn, partner at law firm Weil Gotshal. Jim, welcome. Thanks for coming in.
Hi, I'm glad to be here.
So now what? Are we going to play football next year, and what needs to happen to get us to that point?
I think it's very likely there will be a season. Certainly that's what the players have been fighting to ensure that happens. That's why we filed the lawsuit to seek to enjoin the lockout. And the judge, Judge Nelson, has so far agreed with us, and the process has a way to go, but we feel pretty good that there'll be a season.
The owners obviously aren't happy with the current situation. What are the prospects for the appeal process? What's it going to look like?
Well, I would suspect that there'll be an expedited appeal. Again, it's guesswork, because no schedule has actually been set by the Eighth Circuit. But it would be likely, I think, that we would be seeing an argument sometime in mid-June.
Mm-hmm. Now, not to use a pejorative term, but this is a weird case because we're dealing with an NFL season. Timing. When is this supposed to go up on appeal? Do you expect the court to move more quickly because of the nature of the case? Or?
Yeah, I think that they're going to move more quickly, perhaps, than they might otherwise. Clearly, it's going to be done on an expedited basis. I think whatever panel ultimately gets the case is going to recognize the significance, which is not only to the parties, but to America.
Right. So talk to me about the Eighth Circuit. It's known as being a very conservative, business-friendly court, but this isn't exactly, it hasn't been portrayed as a bright-line case. How do you expect them to approach this?
I really don't see this notion of pro-business, pro-labor, pro-management, whatever, being a real impact here. The reality is, first of all, we have a situation where the world's somewhat upside down. You have management trying to insist that their employees be a union, which is on its face almost absurd. And I think that the court, looking at all the precedents, is eventually going to say the Judge Nelson, got it right.
One of your adversaries in this matter, David Boyce, had a really interesting quote. In effect, he said that when certain issues, such sexy issues was the term he used, go in front of circuit judges, they tend to get creative. Do you share a similar concern on your side of the equation? Are you worried about a creative solution to a sexy problem?
You know, I'm going to expect that the three-judge panel is going to look at the law, look at the situation, see the fact that you have 32 wealthy owners trying to bludgeon their employees into becoming a union, and say, does this really make any sense? Don't employees have the right to not be a union and choose their antitrust rights? We feel pretty comfortable about how this is ultimately going to come out.
Right. So outside of litigation, what does the events of this week mean for mediation? Is that going to continue as this process unfolds?
Yeah, we have another date with the mediator on May 16th, and we expect to meet with him for a couple of days. We have always been open to try to get this thing settled. It was, people forget, it was the owners here who pulled the trigger and blew up the agreement, which we had said all along we were perfectly willing to live under. So hopefully we can get a deal at some point, and it'll be a fair deal, and the players will be playing, and I guess the owners will be owning.
As I've been preparing for this interview, I've just been bombarded with questions about your day-to-day existence. This has to be a lot of, in one way, it's got to be a lot of fun to work on this. Are you dealing with players day-to-day with their concerns, or are you just dealing with their representatives, or what's it like?
You know, it's a mixed bag every day. There's a lot of media, not surprisingly, with the 24-hour news cycles. It's a lot different than when I did the Robertson case back in the 70s, Oscar Robertson from basketball. We get emails from players asking questions. I spent time yesterday with several of the actual named plaintiffs talking about some of the issues, had lunch with one of them. So there's lots going on. We have also a proceeding in the NLRB that we're dealing with. The NFL filed what we think is a frivolous charge before the NLRB. And
what was the charge?
Claiming that our decertification or disclaimer was somehow invalid. again, trying to force us to be a union when the players have decided they don't want to be a union. So interaction with Dee Morris, who's both the head of the Players Association and co-class counsel, and Jeff Kessler is also involved. Lots of discussions, lots of letters, lots of briefs flying back and forth.
Sure.
And the players are very, very engaged. And I must say that in dealing with Tom Brady or Drew Brees and Mike Vrabel, and Ben Lieber, both of whom are all of whom are plaintiffs. Mike and Ben have been at the mediation every day on behalf of all the plaintiffs in the class, and they're engaged and hopefully looking to get a settlement of this litigation so players can play.
Now, you've worked with all 4 professional sports leagues in the United States. How did these issues and the way the NFL has dealt with them compare to what you've seen in other leagues? How is this different, if at all?
This one, to me, is far more irrational on the part of the owners. Owners tend to be irrational anyway, but in this particular circumstance, you have a hugely successful organization. Probably
and
by
you mean
far,
the NFL League?
The NFL League and the owners. By far the most successful sports industry in the history of the world. They don't claim that they're not profitable, and they yet have decided on a course that is frankly self-destructive. It's destructive for themselves, it's destructive to the players, and certainly it's destructive to the fans. And the only reason that we can see is that they've somehow decided that they want to make more money than they're making now, and they're making a lot.
Looking down the road, do you think we're going to be having the same conversation talking about basketball and the collective bargaining?
You know, I was mentioning to somebody earlier, I got a call from David Stern, who I've known for some time, a couple of weeks ago, actually wishing me bad luck, which was fine. Yeah, they're very focused on it in the other sports. I'm doing some work in hockey with Don Fear, and I'm sure that this will be an issue in hockey. Baseball, at least as of now, seems relatively calm. And basketball is going to be facing these issues in a couple of months.
Why are these issues coming up all of a sudden? I mean, it seems like all these leagues have been operating for so long. Why now?
Well, you know, there is a history here that goes back, you know, players and owners have been fighting about some of these issues for decades, including this intersection between the labor laws and the antitrust laws. You know, I was involved in the first time the football players disclaimed rights back in '89. We also did it in basketball in '87. And it really, the reality is that you're looking for a balance, you're looking for a fair deal. But if one side or the other seeks to push it too hard, in this case the NFL owners, then it makes no sense to be in a union management relationship. Right. We have antitrust, you use the antitrust rights.
When it comes time to ask what the players are willing to give, what's going to be on the table for them?
Well, we made it, as I said, we made it clear we were willing to operate under the old deal. They weren't. We've said that over the last 20 years, the deal has basically been a 50-50 deal. They wanted to change that and make it far more profitable for them. We want a fair deal. We want a 50-50 deal. We want rules that are not too restrictive, that allow for a fair amount of free agency. And we think we could get this through mediation. We could get it through a settlement. So far, the NFL hasn't been interested.
Wild stuff. Jim, we're going to have to leave it there for now, but we'll certainly be paying attention to see how this unfolds. Thanks so much for coming in. That's Jim Quinn. He is a partner at the law firm Weil Gotshal, based here in New York. If you'd like to learn more about the issues we just discussed, go check out our offerings on BloombergLaw.com and also on the Bloomberg Terminal. I'm Pacchia. Thanks for watching.